So hi everybody. My name is Liat Galily Perel. I'm an IP attorney from Israel. And go ahead and introduce yourselves. Yeah.
I'm Kevin Fournier. I'm an IP attorney. I have my own firm in the UK, Bournemouth, in Dorset, in the south of England. But I'm a US patent attorney as well, and I also practice for the EPO in the UK Patent Office.
Hi everyone. I'm Liat. I'm a US PTO and UE patent registered, and I'm based in Dubai.
Hello everyone, my name is Natalia Zakharova, and I'm European patents attorney and litigator based in Denmark from the middle-sized company Copenhagen Patents Copa.
That's the moderator?
No.
He's
I'm so sorry. No worries, we can just, yeah.
Please run.
Yeah.
Okay. You're coming at the right time to introduce yourself.
Okay. I'm not where's the moderator? I saw him.
And I don't know, I'm going to find it.
It's, no worries.
In the meantime, you can
Yeah.
Oh, nobody wants to sit there.
We made that out to introduce yourself.
Okay. Am I temp?
Oh, we're just doing a
moderator
round
here?
of introductions. Just, name and where.
introduce.
Yeah.
Am I supposed to be moderator or a speaker
No,
here?
just introduce yourself, your name and...
Or hybrid?
Where are you from?
My name is Parveen Nurani. I am a founder and IP attorney at Nurani Global Law Firm in the US. I'm licensed in 6 different states, and also I'm a registered patent attorney at the USPTO.
I'm not sure where to bring it to you. What should we do?
You want us to just start talking?
Right, look into it.
Okay, so half moderator, half speaker. So the session is about IP strategies. And I know some of the people sitting here, and I know they have much experience in IP strategies. And I think the main word is global, being global. Today, everything gets to be more and more global. So it's not enough to know your own IP laws, and many times you have to know. Oh, there's our moderator. Thanks. I was just, leading them up. Like a stand-up. I do the getting up, making them up.
You can.
That's yours. There you go. Yeah.
Hello, dear participants. Sorry for my short late. I'm very glad to open our next discussion today, patent prosecution in key global jurisdictions. My name is Anton Didikin. I'm director of legal firm as a part of Astana International Financial Center. It's a common law jurisdiction in Central Asia. And today we have a good opportunity to discuss the global trends in patent prosecution strategies as a part of our experience and legal practice. That's why I'm really glad to be here and discuss with our speakers today. Let me give my phone our speakers to short introduce yourself for our audience.
We've already done
We've done a round of
You already introduced. I already introduced me, and we already met. So
Yes, I actually think we introduced.
We did a round of introductions.
We did.
Yeah.
We've introduced.
Okay, so it's a good. So the first question for you, because today we plan a living discussion about our basic topic, and the first question, when I prepared this session, I looked the basic information in the global report last year on the global patent statistics, and as we can see, we see the growth of patent statistics in China, India, and countries of Asia Pacific region. And it's a basic global trend that we can see every year. And my first question for you, from your practice, from your point of view, how you would assess and comment these current trends in global patent statistics? What other trends maybe you consider as an important today? Who will be the first? Maybe Natalia?
Thank you very much, Anton. I should say that I generally see a little bit of changes on the markets, maybe how it's going, because of course we see the regions which are developing with the high speed. And I remember very well that last year I talked to many people from India, also in the IIPLA, and then while being there, and I realized how much support the state gives, for example, in India, to the startups companies, which makes, of course, this the place where maybe also the global players want to increase their presence, right? And I think I generally see this tendency which you mentioned, that we have the jurisdictions where maybe we even need to think, from my point of view, from European perspective, maybe we should think even more than we do at the moment. Because I can say that from the clients that we have in Europe, it's of course also a bit a question of costs, which jurisdictions we go, right? So the patent protection is not the most cheap thing, still in spite of all the globalization and everything, is still very expensive thing. And for small, or even for maybe even for middle-sized companies, it's a question also which jurisdiction we go, where we actually need this protection. And I think this is maybe for us in Europe, I would love to also hear the experience from all over the world for us in Europe, to understand a little bit whether there is the need to maybe even push the clients a little bit, to explain them more that yes, it might seem unnecessary even now yet, but it's the tendency where it goes. So you will have to face it, even if not now, but in a couple of years.
I think from the perspective of the GCC, as you were saying, we could see jurisdictions trend and also technology trend. From the jurisdictions point of view, in the GCC, I think there have been so big leaps towards the number of patent applications filed in the last few years, especially in the UAE and in Saudi Arabia. The reason behind that they took too much many steps towards simplifying the prosecution, accelerated examination, PBH programs, making a lot of efforts to make things much faster for clients, and at the same time make examination at a higher speed. Like for instance, in the UAE, they have what's called a patent hive program, which is really will shrink the time of prosecution from 42 months just to 6 months. On the trademark, they are making right now a same-day examination efforts that you can have your trademark accepted or rejected on the same day. They also have what's called trademark online market, where you can sell and buy trademarks that you have. All of this resulted in really high number of applications and a big boost for the amount of applications we are seeing. Lastly, I would like just to say, we also see trends, as Natalie was saying, about different trends in the technology. Obviously AI, everybody's talking about AI and related healthcare, automotive, whatever. There's also the green applications, where also in the UAE we have what's called green fast track. If you have a sustainability patent application, you can go ahead of the line. There is also the SEBs. There are a lot of patents application coming out of that, and we see a big leaps in these technologies in the number of applications.
Okay, so the areas that I handle, the geographic areas, which are the US and the UK and the EPO, so it's a little bit of overlap with my colleagues here. I think there's been an increase in the filings at the UK Patent Office, partly because when there's a small entity, a small enterprise, the EPO is just too expensive for a lot of these small companies to pay 3,000 euros just to file, and then 1,000 euros every year. It's very expensive, so I think this is seeing a push towards the national patent office, such as the UK and German patent offices, two major European, filing jurisdictions in Europe. The UK office has seen an increase in filings, and the filing fee is now going up in the UK. They're by like 25% in April, which is going to be a huge change. So I think reflecting the high filing rates, and also the US PTO has seen an increase as well, and it's now like 2 years I'm seeing to get an office action. This is what you may have seen the same. So I mean, it's a very, very long time to get a first office action. The examiners have quite a backlog. So I think that shows the high number of filings.
Thank you. I also agree with my colleague about speeding things up and getting more options in order to speed up the examination. I think it really helps. People get certainty faster. So I think that might be one of the considerations when somebody wants to file a patent or a trademark. I also agree that AI is also part of it. I actually had a client where I sent the draft of the patent application to him, and he gave it to ChatGPT to give me remarks about my work. And I found myself going back and forth between me and the AI through the client. So people, it's good and bad, because sometimes clients send you something the AI wrote and say, oh, he did all your work, so what am I paying you for? Or you have less working hours. So it has its benefits, and it's also, it could be a challenge with the clients. But people start believing that it's possible to file a patent without taking a mortgage. So that's also a good thing. Regarding trends, I have to say I found a research that was published recently, which showed that after crises like COVID, wars, people get very creative, and you see an increase, a very high increase of patent applications. So because people, you take them away from their comfort zone, and then they get creative. And when things go back to normal and they can afford it, they file their patent application. So we see an increase. Israel is at war since it was forever, but still, after hard times, you see it very. It really shows.
Okay, thank you, colleagues. And maybe some additional question for you. What changes in domestic patent offices in legal firms in these current trends when we try to compare some different jurisdictions in the global trends that we discuss now?
As US, you know that every 4 years when the new president comes, there's a new director for the USPTO, and Mr. Squires become the new director of USPTO, and he claimed to wanted to be very efficient, faster prosecution and everything. So, and he on his first day he did sign a couple of patents, couple of inventions to become patent. And the another thing he did was he took over decision on PTAP, which usually there was a board of people who were writing decision on the result of whether something is patentable or not. He took over that. And since he has took over, it seems, they say the statistics shows that people who file IPR, they are having a hard time to get their way. So usually the patent owner wins rather than somebody goes against them. Another thing is happening in the US is there's a bill going through, pushing through the Congress, which I talked in another session as a question, that regarding eligibility And some people say if that bill goes through and through the Congress and Congress approve it and become the law, then eligibility is gonna go back to where it was before Alice's case, because Alice made it harder for people to get patent for business processes or the software, and they were saying that Europe and when AIA came out, those like 10 years ago, there were conversions, but right now if these bills go through, I think is going to be much easier for the US, for the business people, for the people to get patent for the business processes, as well as the software, and I believe it's going to increase the number of the number of patents being given, and we shall see. Also, there are talk that patent examiners are going to use the AI, and they're going to get to the point of AI basically negotiating between patent examiner and the attorneys, and even patent, as long as there is a people involved in the invention and people involved to significant point, is okay to use the AI. AI can be used in the court as well. So these all should be considered when you decide to prosecute your patent, because eventually somebody file a IPR against you. The third party might come and have you do a EPR, which is like the ex parte examinations, which in a way, if you get ex parte, then you can make your claim much stronger. So you have to kind of, I'm coming from the background more like the both prosecution and litigation, so I feel like you gotta see both what the trend of litigation going on, especially at USPTO right now, the way it is IPR, as well as what's happening at the district court, as well as the ex parte, and which seems like what the new director has shown, that he's going to be around for another 3-4 years. So you got to kind of adjust yourself as well, and it makes the U.S. very more uncertain, because every 4 years you have new president as well as the new director, and each directors have their own agenda.
And then what's happened in the European region?
Thank you. I think Europe becoming, in my view, again, it's, I should say I'm in telecommunications, so I'm not in pharma area, right? I'm in very engineering technology. I have the feeling that the speed of prosecution is actually much more efficient now. Maybe my colleague might have different experience, but from our clients, I can see that the examination really improved even more. So I know that the EPO was working on it for a while to respond fast, to provide the European patent search fast, and generally to speed up the decision. And I think they are being pretty efficient in this, and there are also instruments which are working to some extent to speed up the decision for the client, which sometimes a good thing, sometimes might be a little bit to push it to oral proceedings when we have to deal with this. But at the same time, my personal opinion is it's also not bad, because then you have the decision, you have some predictability, and also in the oral proceedings, you have the opportunity to maybe more efficiently protect your client's interest, especially in where I work in our field of technology. It's still a little bit challenging in comparison with US, I think, because maybe also because we work with US clients, and I can see this difference then in the area of telecommunication, the area of the software related, the AI, this area, it's still, the EPO has very, very different approach than USPTO, and we have like last Friday, I had the situation that we have to struggle for 7 hours for the patents, which was granted in the 6th auxiliary request only during the struggle, with a lot of amendments and in much limited scope. And for the same application, it was the much broader scope received in the US. So I think this tendency is also for us still, as the European patent attorneys, especially working with the clients from such jurisdictions as the US, which has also a very different view on the amendments, on the introducing amendments, on the basis for the amendments. We ongoing have these challenges. And of course, one of the maybe most important things in the litigation at the moment is the UPC, which in my personal view is also pretty efficient at the moment. I think it's growing. I have the feeling that the company is a little bit divided in those who said, no, we will wait and see what's going on and we will just withdraw from the unitary effect generally, right? And we also have other companies which feel themselves more confident to go for this unitary effect and to very effectively try the system. And as I mentioned in the previous session, also in June this year, UPC launches the new Patent Arbitration Mediation Center. So we have a lot of ongoing from the side of the litigation, where we would really like also the client to try these new instruments and to make it maybe more efficient. Well, yeah, to try alternative dispute solutions instruments.
Again, we have to put the GCC in general and the UAE in the context of emerging IP countries, which means that a few years back, maybe 7, 8, maximum 10 years, we were oil-based economy, and now we are switching to knowledge-based economy. And that comes that you have to really be having your internal AB set up in the best option that you can attract investors and startups and all of that. With that said, and now the GCC is not a secondary profile filing or patent applications or trademark filings, but it's actually an innovation and powerful hub for startups and SMEs and also big companies. We can say that really internally there have been a lot of laws came out in the last 5 years, which established really the structure of everything. The patent offices and the trademark offices are really on the right track, having faster examination and prosecution. Things are going in a way that right now, as we were saying, you can in 6 months or same day have your application examined, and that's a big leap for us over here. At the same time, we see a big movement on the startup side, where there are a lot of accelerators and incubators over here in the region that attracts funds and VCs, and at the same time that creates a lot of patent applications and a lot of applications in the front offices. Also, because of all of that, we could see that right now applications are originating not only from outside in, but from inside out, and that's really positioned UAE to be on the Global Innovation Index at a good ranking. I believe this year they are 30th place, which is really interesting and set up the stage for a big boost in the next few years to be able really to generate inventions inside the UAE and the GCC. What I believe we need to have change it. Saudi Arabia, for instance, have right now a draft for a law where they are adopting AI new guidelines. So they are on the stage for that. But I think we need to be having more specialized examination in the patent offices that understand the technology in much better way and have our own in-house examiners that are experienced. And they are building that right now, but I think we need a few years to achieve that. But it's promising so far.
Okay. The UK Intellectual Property Office is extremely difficult on accepting patent applications on software, and even more so than the EPO in the US. So while I said earlier that the UK filings are increasing, if they're in the software area, they give you a really hard time. There's basically 5 hurdles or guidelines from a court case called HTC that have to be satisfied, and they're all extremely computer architecture oriented. Like, you really have to be improving the computer system, or if you have data that is in a specific content field, like whether it be video or audio or text, or if the data is in any special form, that is not good, because they want it to be just generic data that's processed by a processor, or being put into memory in a special way, or something computer architecture oriented. Anything that's application related at the application level is very hard to get. So yeah, we're really struggling at the moment. I just filed a response to a very interesting invention for a UK client who couldn't afford to go to the EPO. It couldn't spend the 3,000 some euros and 1,000 a year, in renewal fees, whatever, very similar to that, to get a European patent. It really wanted just a patent in his home country, but it's just not. I really struggled to put together a response. I think I did a good job, but but you just have to go through all these guidelines, but they're really hard to meet. So I think that's a challenge.
Oh, wow. Well, other than you, everybody here was very optimistic, saying how things get better. Anything good about the EPO? About the UK office?
Yeah. They help you, and they point you. If you have an invention in the right field, they will point you. They will point you towards allowance.
Okay,
yes.
well, good.
Yes.
Okay. So I guess what I'm hearing from most people here is that the patent offices, directors hear the public and try to go along with what people need, which is fast proceedings and certainty, and I think that's a good thing. I don't think it was always like that. So many changes and so fast, and in so many countries. I think there were years where the patent laws, they had no changes, nothing ever moved. You would wait 3, 4, 5 years just to hear something from any examiner. So I guess that's a good thing. I can say about Israel that they're really, really making an effort to hear the patent community. They have roundtables and online discussions, and they're saying, what do you need? What do you want? We can't promise we'll do it, but what do you want? What do you need? For example, some people said they wanted a provisional, like in the US, to be in Israel. So they're discussing it. They might not do it, but they're discussing it. They're hearing people. They're communicating. Also, since Israel is a small country and you have like hundreds of examiners, you can actually connect with the examiner on a very personal level, and you can have his phone number and his email, and it's not, in many countries you don't have that, so you can just pick up the phone and just ask him a question, and that's very helpful, I think, for many clients. Also, they're always improving their services, their website, they're like online. Sometimes it's hard to keep up with all the changes going on all the time. And each change, whether it's a law issue or a technical issue like a website, they publish it first to the public for comments. So I think that's a very, very good thing. And they hear people, they change things according to that. And if I could give like 2 examples of that, one of them is getting the examination reports in English and not in Hebrew, so that, we might charge less fees for translations, but the clients love it because they don't need translation. They can just see what the examiner wrote in his own language. So you can actually request that all of your examination reports will be issued in English, and that's a good thing. And another thing is we have on the website the time period for examination. So I can tell a client if he's going to wait 30 months or 40 months, or the exact time of
40 months.
So I think the point is that patent offices need to adapt. I think most of them are doing it. And I think that's a very, very optimistic point of view.
Thank you, dear colleagues. And maybe we comes to second basic topic about the strategy of patent prosecution. And I want to ask you, if your clients ask you recommendations on this, what kind of strategies can you recommend? And what in your practice patent strategies really works today? What kind of strategy?
In the US, I feel like even like there's the life sciences, and then we have the AI and the software and technology, high tech basically. And I did a paper a few years ago, and comparing the cases, getting to Supreme Court or getting through CAFC, Court of Appeal for Federal Circuit. I realized at that time they were favoring giving life sciences, especially pharmaceutical patents versus, like, let's say big companies, Microsoft, or the small companies who were doing that was on the high tech. You're going and making it harder, especially by like Alice case and all that stuff. So it became harder for small companies who were going against Microsoft or some of these big companies to get a patent. And then the politics also play into it as well. Like, I don't know if you are familiar with a case, it is well known as a skinny label. It's a pharmaceutical case, and actually a US pharmaceutical company suing a generic company in UK. And this case went to district court in Delaware couple of years ago, and the Delaware basically said they're not going to take it, and then CAFC took the case, and then the generic company lost that at CAFC, and right now, about a month ago, they appealed to the Supreme Court, and Supreme Court decided to take a look at this case. Similar case, which Teva had another pharmaceutical company a few years ago, has similar to this skinny label, and Biden administration really wanted for the court to take that case, but the Supreme Court didn't take it. Right now, I feel like the Trump administration, since it's pushing for the lower cost of medication, lower cost, so they are basically pushing for the generic drug company to win this case, for the Supreme Court to take a look at it. So it seems like if you look at the history of these skinny label, which actually maybe some people don't know, is like there is a law that if a generic company put just what the name of their generic they're using, and they just say what is the main problem they're going to solve, not any other problems the original pharmaceutical pills were solving, they're okay, even though they might be infringing on the issues. So right now, if this case goes to Supreme Court taking it, that means it's okay for the generic company. They put that skinny label and just be okay, even though they might be infringing some of the cure that's like the pills, the original pill was curing. So I feel like the politics, everything goes into it. I don't know how much is in Europe or how much is UAE, but seems like that's the agenda for the administrations, and then the director changing every 4 years, so all this stuff play in it. And right now Supreme Court is more like the right than the left at this moment, so all this stuff kind of play into it.
I think the strategy choice depends still crucially on the size of the company and all on the finances behind the company. Because as we mentioned a couple of times also, even just getting the European patents, it's already a big deal financially. And if you think about going, and we talk not only about getting the patents in different jurisdictions, right? But we talk about also maintaining these patents, and I don't want even to go into the litigation costs if you think that you should go there. So I think the strategy varies for our clients a lot depending on the clients. And I have several startups companies with whom we work, and there I think it's maybe more careful strategy. If it's a Danish company, then starting from the Danish application, giving a little bit time, which is maybe not the best way always, because I work also in in the very speedy developing technologies, but sometimes there is just no way doing it otherwise, because unfortunately I still see the cases where small companies, they are very ambitious, they have amazing technology, and they think, okay, we just file the application, and then we are there, and we get investors tomorrow, but then it's not happening. And then they cannot really protect themselves, so they don't have capacity anymore to protect themselves. So I think it's varies crucially, and I have, at least for my clients, because again it depends on the industry, it depends on the competitors, right? But for my clients, I can see that the clients of like huger size, I would say, they may be more faster, they may be more even sometimes, okay, we just need this patented as fast as possible, we need the pile of the patents maybe as fast as possible. Whereas the smaller clients, we try really to a little bit be more careful and to give them more time to solve their business issues first. And also one thing which I have the feeling I'm talking everywhere about this, but I cannot stop talking about this, is talking about strategy. It starts with the discussion of the invention. It's not starting with filing the application, right? And the strategy discussion starts, so before you start drafting, you think which jurisdiction you go. Because it's crucial. Again, when I see applications drafted specifically for US, I cannot judge the quality of these applications because I understand they're simply written for the jurisdiction where approach is so different that they don't have problems that we have. And of course we're struggling again, we're trying to explain also the examiners that maybe it's time to be a little bit more modern, but the problems are still there in UK, the problems are still there in the EPO. Right? Generally the law is different, it's civil system more than case law system. So I would say my strategy is again, before you start thinking about draft application, think about where you go. Think whether you need the expert in this particular place, maybe even if you use AI as the draft, just to check, just to see, just to give some hints, saying, just put these 3 paragraphs there, just put 3 additional features there, just to be safe.
So basically, in the UAE, you just reminded me that in the UAE also for startups, we have 50% off for examination and prosecution, which is really a big help and big hand if you are a small company that really can have still your IP and it doesn't stop you from there. For the strategy, basically, I think that will not add much because I think the community here is in the field. So, but I will try to remind people. I think it's more about business alignment. Like we need to understand what you are thinking business-wise. What's your business plan? What's this model? And we need the IP also strategy to go with that. We need to be cost-effective, which means that if you feel that your competitors are also filing or manufacturing somewhere, or their R&D are somewhere, so we need to protect there because that would help you on the long run. Sometimes clients ask us about to nominate some countries, which is not our job to do that, but I believe we can help them by having the GDP for these countries for the next 10 years. Are there emerging markets that can be really having a good return from them or not? On the drafting issue, as you were saying, definitely it depends on each jurisdiction, but when the client comes and tell you that I need to file in the US, Europe, and China, then you are really in a big hole. You don't know where to go. But the major thing here, it's also if the client have or has somewhere where we have weak enforcement, like the enforcement is really not like sophisticated like in Germany, Japan, or the US, then we need to advise them to have contracts more strict, to have maybe trade secrets for some aspects of the invention or something. So it really depends, but by the end of the day, you need to have the drafting to the audience. So who are the audience here? Basically in the US right now, I believe the USPTO got a rule or something that you cannot go to the IPR, you will be rejected if you will have a trial sooner.
There was a case.
Yeah, so if you have something like this, so the draft should be directed to the jury and regular people thinking rather than patent examiners if you are going to the IPR. So right now, a lot of factors goes into the drafting thing. So, and more it needs to have somehow a unified draft for different jurisdictions.
Yeah, these days, I mean, as I mentioned, since the director of USPTO took over the PTAB, right now people say don't even try IPR, just go for APR or just go to district court and try to do it through other route.
Yeah.
Kevin, what is your recommendations on strategy?
Strategies.
Lost hope.
There's no more hope. Let's all go home.
Be optimistic.
So it's about IP filing or prosecution, which both? Prosecution, right, okay. So one strategy for IP prosecution is oftentimes clients will come to me with a lot of related inventions all at the same time, and they don't know, that I always tell them an invention is a problem-solution pair. One problem, one solution, and then if you have another problem and solution, it's another patent application, really. But sometimes they don't. It's very late. Maybe they need to file quickly. They come to me with a bunch of problems, a bunch of solutions, all in the same field, And so you can file this like mega application, that has all these related inventions in it, and then later, once it's filed, you can file continuations and divisionals in different countries, to seek protection and change the claims and for each one, and then claim priority within 12 months from the first application. Yeah, so that's just one thing that I've seen more and more of recently. I mean, I tend to want to focus an invention from the beginning, a patent application on one invention, which is ideal, the ideal thing to do, because you have to draft the background and the summary and, everything, for that one problem. But oftentimes you get these multi-inventions coming in all at once at the last minute. You have to be creative, and that's just what I've been doing lately.
Okay, so I'll focus a little bit about strategies involving Israel. So in Israel, you have a lot of options for expedited examination, and we can see on the annual reports from the LPTO that more and more people file for an expedited examination, and you don't have to be an Israeli citizen, so you can use all of these options even if you're not first filing in Israel or an Israeli citizen. Basically, I think that for foreigners, a lot of times Israel has become a bit of a stepping stone for getting expedited examination worldwide. So you don't, as opposed to trademarks, for example, you don't have to actually use the patent. You can file a patent and you can never have a product, and that's legal and that's fine. So if you file a patent application in Israel and you get expedited examination, you get your examination report within 3 months, you might get a grant within 12 months before you even have to file your PCT application. And since Israel is a member of the global PPH, you can actually have PPH all over the world, most countries, and then for Israel you just have the filing fee, the examination fee, which is not that high, and then you can have PPH for many countries in the world. So that's a strategy that not all of our foreign clients are aware of. And that's one aspect of it. We have so many options for expedited examinations, first filing in Israel or after a provisional, U.S. provisional also. Just for that, you get an expedited examination. We have age, medical condition, green applications as in other countries, possible infringement, PPH, long waiting time, that's also one of the reasons you can ask for it, and special circumstances. The law says special circumstances. So basically, if there are any special circumstances, we can actually try to ask for expedited examination in certain cases. So fast examination brings in certainty, saves you cost, and Israel is a pretty strict country, so if you get a fast grant in Israel, good chances that you might have a grant in other countries as well. Also, Israel has a very unique clause in its law. I don't know of any other country who has it, and please let me know if I'm wrong. Israel has a clause saying that if you have a parallel application in a list of countries, Europe, US being in that list, if you have an allowance, a grant in one of these countries, you can ask the examiner not to examine your application at all, to just get an allowance with no search, no examination at all. I'm not aware of any similar clause in other places. So I'll tell you the countries, see if you're there. Austria, Russia, Germany, US, UK, Canada, Denmark, Japan. I mean, there's like a list of countries, and a lot of our clients are not aware of it, so it's our job to let them know. But if you have clients who have an allowance in one of these countries, you can say, oh, you know what, you can get a patent in Israel with no examination at all. You just have the filing fee, allowance, you get a grant. So I think that's that's kind of great. And one last thing, you can file a patent application in Israel with an expedited examination, get your first examination within 3 months. Now imagine the examiner found something, some prior art. You can just withdraw your application. It's never published. So, you can keep it a secret, maybe have it as a trade secret. So that's a very nice strategy. I mean, people can get a certainty about their patent within 3 months and then decide business-wise if they want to publish it or continue with it. So that's just like a few strategies.
Thank you.
So you have the 18-month publication rule?
Yeah.
Okay.
We have the 12 months Paris Convention and then the PCT 18 months. But the thing is, if you get an allowance before you file your PCT, PCT is money. Mm-hmm. If you get the allowance before, you have certainty. The client feels better about spending this money. He says, okay, good chances I'm going to get a patent in other places as well.
Yeah.
Certainty is the game.
Thank you. Our speakers talks about deep tendencies in patent prosecution strategies. Maybe our audience, have you got any questions to our speakers now?
Please.
That's great.
I have a question.
We were interested.
Yeah, very good.
Yeah, so you guys all familiar with U.S. practice, so I am too a little bit. But what do you guys, when you speak to an applicant, when you draft the application, and you plan to file in different jurisdiction, what drafting strategies you guys offer? Because especially on the software side, the AI side, U.S. has a very specific set of rules that allows us to get patents. You know, we work with a lot of software-based inventions. So, do you guys do any of those? Because I come from a context where I get some applications, especially coming from Eastern Europe, that we're not going to get a patent. Period. So, and that's really based on drafting, not really patent prosecution strategy. So, just kind of where you guys at?
Okay.
Who will answer?
I would go with the strictest. If the U.S. is the most strict, draft it. Go with the worst.
Strict, but that's.
Yeah.
The UK is strict, according to my negative view. No, go ahead. Yeah, please.
Because I think it's pretty funny because we all have the feeling when we're inside the jurisdiction, we're all like, I would also say, no, Europe is the jurisdictions, of course, right? So when we're inside the jurisdiction and we see every day some issues, we challenge with them, right? I think it's a very, very good question because I think, especially if you have like maybe 2 weeks is still okay, but you have sometimes 1 week to draft the application. And you don't have much time to consider. And then they say, yeah, we just go here, but then in half a year they say, yeah, we want a PCT, and they want this, and we want this, and we can maybe file in PCT, we can try to correct some issues. But I have an idea, but I think it's a little bit unrealistic. But I think the best way is if you can actually try to you have the description, right? And you can have, even filing PCT, you have claims which you can try to adapt already upon drafting for different jurisdiction and keep them all there. And then you have a little bit more variety. But I also understand this, unfortunately, this is, practically speaking, frankly, it's not always possible to do. It's not always, I personally don't always have time for this, to try even to check everything. But I think that I would suggest just to try to have a little bit, maybe specific claims, even that you know this you are going to use in Europe, this you are going to use in US, and to have all this, what is addressed.
And one thing you mentioned, you said you get application from Eastern European for software. The software, they cannot get a patent.
It's not system, software related.
Okay,
Yeah.
software system
Yeah,
that they could be patent, they could file in EU and they could get the patent as well as US basically. But I mean, in general, I mean, law firms, usually they have people who they have different individuals who do the drafting and the specification, and when it comes to the claim, it rely on the patent attorney to write the claim, because the claim, as you know, is the border of like a land that you have a border versus you and the neighbor. So the claims are the main part. I mean, the specification or the other part of the drafting of the picture or others. I mean, the subcontract is to the outside company basically. So if something is complicated, it require really like a skillful drafting. They gotta find the right person to do it.
So who's drafting applications in your case?
I mean, I have heard like talking to people in the different law firm, like they have people who do the picturing and stuff. They are part of it. I mean, the specification, but the attorneys where they involved, they involve on focusing on the claims, and when they do the prosecution going back and forth, it's all about the claims, how you change the claims in order to become patentable.
I think if you find a technical structure or element that is new and solves a problem that the like an engineer would have had to have come up with it, not a business person. If you can identify, that's what I look for when a new client comes to me, like the ones you mentioned. If they came to me and it was a pure business problem, and I didn't see that they would have had to solve a technical engineering type problem, and maybe a business person invented it, and it's not something that an engineer would have had to have invented, and there's no technical feature that distinguishes that's new. There's no data structure, for example, that has different formats, or something that the processor would have to run, or something that makes the memory or the processor work better, or something like that. Then then if it's a pure business invention, it might not be worth filing in any of the countries that we've mentioned. But I think if you can find that, and a real engineering invention, and focus on that, and don't claim the result. I was like a lot of people try to say, claim the result. We do this, and we optimize this, and we detect this, and then we do that. How do you do it? I always say how with the 3 capital letters, HOW. How do you do that? And then if they can't tell me how they do it, then it may not be worth filing. If they do it all ways, we're claiming all. That's the other thing. If you're claiming all ways of doing something, it's probably not patentable. But if I always tell my clients, leave something on the table for competitors, and then you can probably get the patent. If there's like 5 ways of doing something, and you're claiming one of them as yours, and you're leaving 4 on the table for others, then you're probably not claiming all ways. You're not a result-based claim. You're a specific engineering technical claim that's your way of solving this problem. So that's what I tend to do.
The bottom line is not black and white. It all depends.
Okay, thank you. The next question.
Yes, well, first of all, thank you for your insightful and very valuable comments. I think has triggered so many questions for me, and we will have a very nice debate. But I have a particular question for Natalia, because I missed something in your presentation. When you were talking about for the startups, in a certain moment you said that somehow these startups, small companies, cannot protect themselves. I didn't understand what you meant with this thing. Actually, because the other way around is that they don't get anything, they don't have empty hands, and they have nothing. So if they file a patent application, even if later on they don't decide to continue or whatever, at least prima facie they have a filing, they may have a positive preliminary report with the positive things, something that can attract here. So maybe you can explain, because I didn't get this part. And thank you all for your presentation, by the way.
Yes, I think I understand you. Yes, I agree with you. It is better to file, well, not 100%. Sometimes it is better to file something to have at least this passive protection, right? That you have something published, and then you know that at least you don't have any other companies who will come to you and can stop you, right? This is already maybe at some points better than nothing. But I feel very, because I'm much more attached, I should say, maybe I shouldn't say it loud, but I'm much more attached to my startups clients than to other clients, because I work specifically then in this case with inventors more than in other cases. And I feel very sorry when I see that the problem is not that the invention is not new or not inventive. The problem is not maybe that even it's drafted bad or something, but the problem is just that the patent strategy from the beginning was built in a way that it did not consider the long run, the long-term run. So unfortunately, what I still see, and I saw it not only working in Europe, I saw it sometimes working in Russia, and it's not the decision of European or patent attorney, it's not the decision of consultant, sometimes it's the decision of the client, right? When they don't consider it as so they hope for the very fast award for what they're doing, right? And they don't see this long-term run, which involves a lot of financial, which involves a lot of money. Because unless I saw startups which just say we need to file application. In 1 year we're selling the company. We're almost sure. We have 3 people. We're talking about a 3 bigger company, bigger place. We're talking about we need something as a active for us, which we would attach to the cell, so to say, right? Which also shows that we are give more value to what we're doing, right? But if this is not the case, if they want to try to build something on their own, I sometimes see this, that they cannot go further because they're out of money. Because in the beginning, they put this money somewhere, maybe where there was not essential, to speed up the getting patent in the jurisdiction where they are not even sure they are going to sell, maybe, or to produce. And I think for me, this is more what I'm talking about. And again, I understand also, yes, that it's better to file in some cases, especially if you're the smaller player, it's maybe better to file and to have some at least passive protection from something. But also my personal opinion, I don't know, maybe sometimes, depending what you have, because some companies, they also don't want to reveal, some startup companies in IT, in high tech, they don't want to reveal exactly what they're doing, right? They try to do it in a very abstract term. And then sometimes I'm not sure how good this passive protection is also. Did I answer the question more or less?
Well, has triggered many more questions. Sorry, I will have a...
I don't have also black and white, unfortunately. I'm sorry.
We can discuss in the break.
Quick question. When you mean file, you mean drafting the things to the lawyer or submitting it officially? Like you say, they need to file it. You mean file it, which is submitting their, what do you call it, their patent? Or if, let's say, I don't know, this is just basic for me, okay? Let's say that you have an idea, you just make the drawings or whatever it is, and you draft the idea and you write down the scope, everything, and you submit it to the lawyer who's gonna upload it somewhere instead of you. So is that, when you hand it over to him, is that considered as filing?
I don't know how in Europe it is, but in the US you can do a priority filing and get your date, early date that your invention start there, and if anybody infringes from that day on or come up with it, I mean, they're liable to you. So the filing, you do the file, you can do it like I think it's like 18 months like filing, and then after that you have to complete your patent, you gotta have the specification, claim, everything else within that period, and then the 30 years that you have, the patent is valid, start from that day, but you get like a year early, you can file it based on not completed file to get that filing date. So there's a filing, and then there is one filing that you file it, and then another file that you file it after that you have to do, and from that day, the 30 years start the ticking, the clock that goes like that your patent going to be expired after 30 years.
Thank you.
Just a small note, when I was talking about the Europe, what I meant was filing is the filing date, so when we file officially with the European Patent Office.
Any more questions?
So, dear colleagues, our time comes to an end, and I want to thank our speakers for a deep discussion on our topic and our participants for their communication and questions. I think with great work today, and now we'll have a time for a break before award nomination. That's why we need to close our session panel. And I want to ask to help our organizers to finalize our session today. Thank you for attention.
Thank you. Thank you.
I request Mr. Anton to present the mementos to our panelists.
Oh, yeah.
What's that?
It's a microphone thing.
Liat, Galily,
The
Perel.
microphone transmitter.
Please.
I think so.
Especially with doing so talk. Kevin from here, please.
Okay, hello.
First time seeing him. Say hello. Sorry.
Which one do I look at?
He said hello, so as if it's first time to see him.
It's Anton's. And this is for Anton.
Oh, thank you.
Please join for the group photograph. Group photograph.
What happened to mine? I'm not giving one.
You want to come? Group photo.
He still needs his.
Oh.
What happened to mine?
Guys, let's take the photo.
Okay, I guess they got it.